From the News Channel 5 Network, this is Inside Politics.
Hello, everyone. I'm News Channel 5's political analyst, Pat Nolan. Welcome to Inside Politics. This week saw the first Monday in October. That's a traditional date the U.S. Supreme Court begins its annual term to hear cases and render decisions. Last year's term was likely the most controversial in recent years, perhaps the most tumultuous ever, and it appears this year may be more of the same. Joining us to discuss the cases that the court plans to take up and the many other controversies that seem to be surrounding the High Court these days is MTSU political science professor Dr. John Weil, who's also the Dean of the Honors College down there. Dr. Weil, it's good to see you again. Welcome back to the program.
Good to be here.
Even as the justices began their work this week, the controversial nature of the term became even more apparent. Late Tuesday, the lawyers for former President Donald Trump asked the High Court to intervene in the ongoing legal fight over the 100 classified documents seized by the Justice Department from Mr. Trump that he had been keeping in his home in Florida. Is allowing the DOJ to review the documents as a part of the criminal investigation, is the court likely to get involved in this? Do you think they'll take it before the election?
I think they would do their best probably to avoid a so-called October surprise. If they did it, they'd be more likely after the election. Usually the court's most likely to intervene if you have split circuits, if you have circuit court in one jurisdiction saying one thing and another elsewhere, and so far that hasn't happened. So I would probably wager against it, but it's certainly a possibility.
Last year, the court overturned the constitutional right to an abortion while widening gun rights and religious liberties in public education. Is the new 6-member conservative majority on the court poised to do still more of the same this term?
It's hard to tell. I think Chief Justice Roberts is trying to steer a more moderate course. Of course, we have a new justice. One of the fascinating things about Ketanji Brown is apparently during arguments this week, she spoke as much as any other justice, which is highly unusual for a new justice. So we will see.
Is the Chief Justice no longer the lead of this? Is he no longer the leader of the court? He used to be the one that brought them together behind the scenes to put together some cases or some decisions that perhaps weren't as controversial as they might have been. That doesn't seem to be happening anymore.
It doesn't. It's a little early to tell what's happened, but of course, it's when you think about how justices are appointed now, how controversial they are, how partisan it is, herding cats would probably be an understatement for trying to get consensus on the court.
Cases usually come from the lower courts, as you mentioned, and the appellate courts. But it seems in recent years there's more of a concerted effort by conservative groups and by some states even to create cases intended in new laws to take advantage of this conservative majority that has emerged after Donald Trump appointed 3 justices on the court during his term. Is that the way this has always been, or is this something new?
It's certainly been that way since the beginning of, I would say, the 1930s, the civil rights movement. There were many cases that preceded Brown versus Board of Education and many that came after in which cases were strategically chosen in order to get the result that was wanted.
The court this week already heard one case that could significantly limit the power of the federal government to enforce the Clean Water Act. That's a law on the book that's been on the books for decades. The case concerns wetlands and water pollution enforcement. What are the conservatives hoping to do if they're going to change that law in their decision?
The conservatives are generally wary of giving too much authority to federal regulatory agencies. They feel that they're too far divorced from, popular control. And of course, in many cases, these regulations incur financial penalties and costs on industries, which Republicans generally oppose. So that's basically what's happening here.
Last term, the Supreme Court limited the EPA in the terms of greenhouse emissions. Is this about to be a 1-2 punch on the EPA by the court?
It may. Now, those who defend the court would say what the court is really trying to do is they're trying to push back regulation, not per se, but make sure that it is congressionally authorized and within enough limitation so that individuals who are being regulated know, when they're violating the law and when they're not.
Affirmative action has been a topic before the court several times. It seems to be coming back again. There's a case the court will hear at the end of this month that challenges the policies that consider race in making college admission decisions, and particularly to promote student diversity. The argument in this particular case is the admission policy is unfair to students of Asian origin. So far, the lower courts in this particular case have upheld the college admission policies. Might this be the case, though, that the conservatives on the court might end affirmative action?
It might, but to be clear, colleges are not required right now to have affirmative action. So the question is, may they use it as opposed to must they use it? There was a case about 20 years ago in which Justice Sandra Day O'Connor implied that, maybe we needed affirmative action for another 25 years or so, but maybe then it was time for it to end. And so it's a longer-term trend that you see that could come to fruition this term.
Another case the court's going to hear this within a few days involves what remains of the Voting Rights Act. Alabama is challenging a lower court decision that it must create a majority congressional district to comply with the 1960s era voting right law. In taking the case, however, earlier this year, the Supreme Court allowed Alabama to use this particular disputed map for congressional districts in Alabama without a black majority district. There's already one. This case would have created two. Has the court already tipped its hand by allowing Alabama to keep a congressional map that the lower courts had already thrown out?
It's possible. Again, this is where Ketanji Jackson's words from the bench this week were very interesting, because conservatives generally tend to favor what's called a colorblind constitution, and she suggests that sometimes you need to take race and color into account in order to overcome past racial discrimination. Dr.
John Weil is our guest. He's a political science professor at MTSU. We're talking about the first week of the Supreme Court beginning its new term. Back to continue our conversation with Dr. Weil after this break.